Hello, I'm Paul Davies. I'm a Professor of Commercial Law at UCL and I'm the convener for Commercial Remedies on the LLM. So, as the name suggests, this course is about commercial remedies, so we're not looking at remedies for personal injury, for example, but the remedies that you get in the commercial context. And it builds upon the knowledge that you'll have got as undergraduates in contract, torts, equity and trusts. And clearly the remedies that you get are related in some way to the rights or duties that originally owed. So it does build upon and depend upon a certain degree of knowledge of contract, tort, equity and trust in a common law jurisdiction. So those students who haven't studied private law subjects in a common law jurisdiction before will find this course more difficult, and we will expect those students, if they take this course, to do a lot of independent work to bring their level of knowledge up to the undergraduate level. So this course is quite an exciting course. Looking at commercial litigation, it deals with the main areas on commercial remedies. So much commercial litigation at the moment is about what remedies you can get, and the reading involves many recent decisions from the Supreme Court and the Court of Appeal, which we discuss in the seminars. So every week there's a 2-hour seminar where we'll discuss 5 or 6 cases maybe, and everyone will try and contribute their view. And the advantage of this sort of course is that there are so many questions that are open and that are being decided by the courts at the moment. There's a lot of scope for discussion and thinking further about difficult questions to do with the law of remedies. The way it's taught is that the reading isn't from a textbook. So there is a textbook, the Burroughs book, which is on the module page, but it is now very out of date. So the emphasis will be on reading the primary sources yourselves, so reading the cases in particular. And again, students who aren't used to reading common law decisions will find this more difficult and a skill that they'll have to build up very quickly. The content of the course is open to variation, but the first term, most of the time is spent on compensation, so the remedy of compensation for loss. But one of the themes that we look at is that we don't just look at remedies for breach of contract, remedies for torts, and remedies for breach of fiduciary duty, for example. We'll look at all the potential claims as one. And that helps us to examine what the principles are and how the principles differ. For example, whether the rules of remoteness should be the same in contract, torts and equity, whether the rules of causation should be the same, whether it's a claim for deceit or a claim for breach of fiduciary duty. And of course, the same fact pattern might give rise to a number of claims. So you might be paying a solicitor for advice who gives you bad advice, and you might sue the solicitor for breach of contract or in the tort of negligence or for breach of fiduciary duty. And we'll consider how those claims link to each other and why some claims will be more advantageous than another from the perspective of available remedies. So the first part of the course looks at compensation. We then look at gain-based remedies. Again, not just an account of profits and equity, but whether you can get a gain-based remedy in the contractual context, for example. And there's a big Supreme Court decision that's pending at the moment on this very question. And we also look at equitable remedies, specific performance, injunction, self-help remedies like termination, agreed remedies, and so on. So the course tends to be quite lively. The discussion seminars, we encourage students to participate and for much of the discussion to be student-led. So it's a lively discussion that I think students enjoy. The subject matter is obviously interesting, with a lot of issues that are live at the moment in the courts. And it's also very useful for students who are going into practice. So this year there were some students who had pupillage interviews where the scenario problem that was set was basically a commercial remedies problem. So it's useful for those considering going to commercial bar, into commercial law firms in London or elsewhere. So I think that's most of what I have to say. I hope to see some of you doing the LLM here next year.